Hello everyone, welcome to T1 Academy. Friends, today in the rapid revision program with respect to the science and technology, I would like to make you an introduction with respect to the intellectual property rights. My friends, with the topic of intellectual property rights, the prelims questions will be focused on what are the different types of intellectual properties that we have across the world and India, and what are the laws which are dealing with the intellectual property rights. We will not dive much deeper into the intellectual property rights with respect to what India is facing, what is the rank that India is having, not among this. That will be for your mains. That will be a very different task. But today we will be focused on the types of intellectual property rights. Imagine you have created something and someone is using your creation. Don't you think that you should be given certain accommodation for using your innovation? For example, Edison has invented the light bulb. If you are using the light bulb, don't you think Edison should get some credit, some monetary value, something for his effort that he has done? Yes, he should get his credit, right? These intellectual property rights give you credit for your original works, for your innovative works, for your discoveries and innovations. Okay, let's see what is an intellectual property rights. Intellectual property refers to the creation of mind such as inventions, literary, artistic works, designs, symbols, names and images. Not just innovations like electric bulb, but something you have written, something you have composed, like a music composition, some song which you have written, some book which you have written, they are all your intellectual property rights, and the sale and the economy that is created on this intellectual property rights should be shared by you, and that protection is provided by these intellectual property rights. The organization, if you want to understand with respect to intellectual property rights, across the world, when the innovation started, when scientific innovations were misutilized and the original innovator was not given any protection, there started a movement to give protection to these innovators. The first law which dealt with the intellectual property rights in the world is the Paris Convention to protect the industrial property. The next law was Berne Convention for the protection of literary and artistic works. What was the first law in intellectual property, my friend, in the world? The first intellectual property was Paris Convention, which protected industrial property. That is, industries which were doing innovation, we were protecting them. Next, the Berne Convention, which was protecting the literary and artistic work. Some dance that you have composed, some movement that you have composed, some song that you have composed, something that you have written by yourself. Okay. Next, these both laws now today are being looked after by an organization known as World Intellectual Property Rights Organization. And even in the Universal Declaration of Human Rights, Article 27 gives you right with respect to the intellectual property rights. Why am I saying you all these points? Because tomorrow if in your MCQ that which of the following laws deal with the intellectual property rights, then you have to know there is an organization called World Intellectual Property Rights Organization which looks into the Paris Convention on Industrial and Berne Convention on Literary and Artistic Works. There is also basically Universal Declaration of Human Rights. In that there is an Article 27 which will be looking into the intellectual property rights. Even in the WTO, my friend, even in the World Trade Organization regime that we have today, that is protecting our intellectual property rights through a phenomena or through an organization called Trade-Related Intellectual Property Rights, TRIPS. Okay, IPR is protected under WTO regime also. Okay, this is one important organization that you have to remember with respect to intellectual property rights, that is World Intellectual Property Rights Organization. It is an organization directly working under the United Nations Organization, and it is one of the 15 specialized agencies of the United Nations Organization. Okay, it began operation in 1970, headquartered in Geneva, Switzerland. Currently, it has more than 193 members states as its members. Basically, it promotes intellectual property rights, improves awareness among the people across the world for providing intellectual property rights. Now, TRIPS is under the WTO regime. TRIPS is basically a binding agreement where all the countries have agreed that we will be ready to protect your intellectual property rights. Okay, like patents, copyright, trademarks, geographical indication tags, industrial design, trade secrets, etc. And each of these parts I will explain you in detail. What is a patent? what is an industrial design, what is a geographical indication tax, what is a copyright. Now first one is patent. So for what items can you patent? Basically you will see most of the engineering organizations, most of the industrial organizations like Tata company, all those who make innovations, they take patents. What is a patent? Patent in India generally, my friend, they are granted for a new invention. That invention should be novel and non-obvious, and it should have an industrial use. If it satisfies these three conditions, then only that product will come under the patent rights. Then only the product will come under the patent rights. Novelty means it should be new. It should be very new and no one should have seen it previously. And non-obvious means it should have a one innovative step which no one can predict, some innovative step which no one can predict. And this product should have one industrial application. My friends, one important point that you have to remember here is, in India, the patents are valid up till 20 years. That is, if you have designed some particular product, say you have designed a new shoe, a particular type of shoe which is giving the most efficiency to the runners. Okay, you have used some products in that. Now, if you get patent on that product, if that product is economized by some industry, from that economy that industry gains, you should be given a share, and this protection is given to you for 20 years. No one can use this patent without having this your permission. If you have made a patent on a particular product, no one in the world should be able to use this particular product without your permission. Up to how many years? 20 years. You will be given 20-year protection. No one should use that product without your permission. Your permission is necessary. Imagine I have invented a bulb, electric bulb. Now I will have a 20 years of patent that if you are using my design of electric bulb, you should pay me certain amount for 20 years. That is what this protection is. What cannot be patented? You have seen in patent there are three important points that you have to see. One is novelty, right? It should be a new thing. Novelty should be there, right? It should be novelty. It should be non-obvious. That is, some innovative step should be there, and it should have industrial application. But most of the products fulfill these three conditions, but not every product which is fulfilling these three conditions will be given patent. The items which cannot be patented are traditional knowledge. Imagine we use turmeric for healing our wounds. No one can protect the healing properties of the turmeric. Next, agriculture and horticulture methods that farmers practice. No one can patent that this is the method I have invented. This is the cross-pollination method of plants that I have invented. No one can do that. Computer program cannot be. And plants and animals. If you are breeding a new animal, no one can say that this is my patent and my company will only produce this type of particular chicken. No, you cannot say that this is my property. If you have developed a potato, you cannot patent a potato. Patent of potatoes is a different thing. I'll explain that eventually. You cannot patent a particular type of plant or animal. Okay, you cannot patent inventions with respect to atomic energy. Mere discoveries of scientific principle cannot be patented. In India, we have a separate law called Patent Act, and this Patent Act has been amended over a period of time. Just remember, does India have a Patent Act or not? Yes. And today we are struggling to catch the pace of the developing countries, because in developing countries and developed countries across the world, they are going at a faster rate. In those countries, especially in the developed countries, in OECD countries, it takes at least 6 months or sometimes even 3 months to get a patent. But in India, it might go beyond 2 to 3 years to get a particular patent. So that's the major issue that India is facing, delay in the patents. Now, I'll not go further into these patents, but one point remember, it should be non-obvious, it should have industrial use, it should be novel. What are the 3 points with respect to patent? Novel, non-obvious, okay, and it should have industrial use. Okay, novel, non-obvious and industrial use. These 3 points are very important. If these 3 points are fulfilled, you can give a patent. Patent is given in India for a term of 20 years and no one can use your patent without your permission for these coming 20 years. What cannot be patented? nuclear, atomic, I will say atomic applications. And what you cannot patent is animal or a plant. You cannot patent a traditional knowledge, TK. So these are the points which you have to remember with respect to the patent. This is very, very important, my friend. What is a patent? Now next is industrial. The next thing you have to see is industrial design. You see, when you have designed something for aesthetic properties, that falls under industrial design. For example, you see the bottle of Coca-Cola. It has some unique industrial design in them. And no one should be able to use this industrial design because Coca-Cola bottle is their trademark, is their unique look. If everyone is going to use the same industrial design, don't you think it will lead into destruction of the Coca-Cola economy? Right? So in India, basically industrial designs are given protection till 10 years, extended by 5 years. Okay? How many years in India an industrial design is being protected? 10 years for industrial design plus 5 years if you ask for an extension. Okay? 10 years plus 5 years. There in India, we also have a law to deal with the industrial designs, the Design Act 2000. Next, copyright. Copyright is basically you get it for books, something literary works or artistic works. For what that you will get the copyright. That is, if you paint something, if you compose a music, if you write a song, if you are having basically a literary script of a story or something, for that you will be getting the copyrights. For what you are going to give copyright? Literary and artistic works. And artist. On books you will see copyright. On books, whatever book you see, on the end of the book you will see copyright. On advertisements, and all these will be given under the copyright. In India, there is a law dealing with the copyrights, my friend. Copyright Act 1957. You can see copyright can be given to books, music, painting, sculpture, films, computer programs also can be copyrighted. Computer programming can be patented or copyrighted. If someone asks you, a computer program can only be copyrighted but cannot be patented. Advertisements and maps and technical drawings are basically copyrighted in India. Now, one important point that you have to see here is a copyright basically will be valid for 60 years from the death of the author. That is, basically copyright is given to the entire lifetime. Okay, imagine I have created a film. How many times this film is played in the television or in any theater, and the revenue generated by that particular film should be shared by me till I am alive. And if I die today, that revenue will also be shared to my offsprings till 60 years of my death. Originally, this particular patent or copyright, a type of patent or type of intellectual property, is given for the entire lifetime you live. మీరు బ్రతికున్న రోజులు, for the entire lifetime this copyright will be given. Copyrights are given for the entire lifetime, but once you die, your copyright will be valuable up till 60 years from the death. Next is trademarks, my friend. Trademarks are basically logos that you see. McDonald's logo, these are all trademarks. Basically, trademarks are also given protection, my friend. Trademarks are given a protection of 10 years. And India also has an act or a law dealing with the trademarks. Trademarks Act 1999, which was recently amended in 2010. Okay, what is a trademark? Trademarks are logos. Basically, these are your trademarks. If someone is using your trademark without any permission of yours, then that is a crime. You will be also fined for such crime. See, McDonald's Munchie Burger. If someone is using McDonald's logo, that is very wrong. So you will be given how many years of protection, my friend? 10 years of protection. After 10 years, you have to reapply and you have to again and again reapply so that you are being protected. Geographical indication tags. Basically, my friend, these are given for the original products which are designed in a particular region and they are specialized for that particular type of product. For example, Banaganapalli mangoes, okay, Telia Rumali of Telangana, Darjeeling tea, right, Pochampalli Ikkat, silver filigree of Karimnagar. All these are examples of GI tag. Basically, They protect the rights of the community or the people who develop them. In India, GI tags, these geographical indication tags are given for 10 years. How many years, my friend? 10 years. That is also one important thing. So now before concluding, let's write all those points. Number 1, patent. This is for 20 years. Number 2, copyright. This is basically for lifetime plus 60 years after you die. Okay. Third one, for industrial design. You are given 10 years plus 5 years extended. Next, fourth one, trademarks. These are basically logos. You will be given 10 years protection. And the last one, that is this geographical indication tag, you will be given 10 years of protection. In India, the geographical indication tags are dealt with the Geographical Indication of Goods Registration and Protection Act 1999. For all these things, we have acts in India. That's one important point you have to remember. Now, next is trade secrets. Does anyone know what is the formula for making thumbs up? Coca-Cola? No, right? They are secretly protected by those companies so that they can gain economic value. And if someone leads to leaking or stealing of this trade secret, then it is a crime. But in India, there is no particular law dealing with this thing. Okay. Next, in patents, you will see something called as evergreening. This happens, what is this? Evergreening. This happens in pharma sector, pharma. What is evergreening in pharma sector is, what pharma industry do is, imagine this is a particular medicine. For this medicine, they got a patent for 20 years. Now, after this patent has been completed, what happens is, for the same medicine, they want to earn more and more money because this medicine is having higher demand and this medicine is providing them lot of money. Now what they do is, for this medicine, which was an original, say it has a formula of x plus y. They will do small change and they'll make the formula x plus y plus z. They'll add a small new commodity and say, this is new innovation. We have invented new, and again they will ask for a patent of 20 years. Now, this process is very wrong. There is no new innovation. You have just added some new ingredients and saying that this is new. So by this process, what pharma industry is doing, they are evergreen. They are continually holding the patents of this particular product. What happens because of holding of these patents? What happens? Because of holding of these patents, the medicine will become costlier and costlier for the poor, because no other person is allowed to manufacture this medicine without paying for this pharma industry, right? For this particular pharma company, right? So that's why this evergreening is done. Evergreening is changing the slight formulas and saying that it is new innovation and gaining from that is called as evergreening. That is not allowed. This is very, very wrong. Next, plant variety protection. This is one more important thing, my friends. You see, plant variety protection is, in India, no one can say that I have developed this plant, so that's why I will only use this plant, and no one will be allowed to use this plant. That's what is very important. In order to protect the farmers and to protect the farm innovations, what our government has done is, they said no one can patent a particular variety of plant. No one can say that. I developed, so I'll only use. No, whatever you develop, whatever intellectual property a farmer in India develop, it should be shared by every other farmer so that every other farmer is benefited. My friends, there was a famous case of Coca-Cola, where Coca-Cola came to India. They started manufacturing PepsiCo. PepsiCo came to India, small correction, PepsiCo came to India. They started manufacturing the Lay's packets, the Lay's chips packets. Now Lay's chips, they are manufactured from a special variety of potato, which is very big when compared to the Indian continent potato. When these potato seeds were shared with the Maharashtra farmers, they took and they produced the potatoes and they gave back them to the Coca-Cola. But eventually what happened? Maharashtra farmers were able to utilize the remained potatoes in their farm to grow more and more potatoes. Now the PepsiCo started questioning, how can you use my potatoes which are my intellectual property? I shared you so that you can give me potatoes so I can make Lay's chips, but how can you steal my potato formula and grow more and more potatoes to sell in the market? That is wrong. That's what they said. But our Supreme Court has said, no, you cannot claim the property on a particular crop or a particular plant in India. So that's the protection we have. We have a law dealing with this, that is protection of plant varieties and farmers' rights in India. Okay. See, the act allows farmers to grow any plant and exchange and sell patent protected crops including seeds. But it only bars selling it with the brand name. What it is? See, any patented crop, any patented plant, any patented seed, you can buy it, you can replicate in your crop, and you can utilize for your own purpose. And you can even share it to other farmer. See, I got some BT cotton seeds. Though BT cotton seeds cannot be regerminated, you have to buy again and again. But fortunately, my BT cotton seeds were able to replicate in my field. Now what will I do is, I can give these seeds to my friend and another farmer in a beside field. So I can share with him, but I cannot sell these particular seeds with a brand name saying that these are brand of so and so. So you are not allowed to sell them with the brand name, but you are allowed to exchange, you are allowed to use this for your will and wish. Why did we give this protection? Because you are allowing the creation to continue. So this is Plant Protection Act. We have national policy also on intellectual property rights, my friend. Basically, if every 5 years we revive our intellectual property rights, basically to protect or to improve the legal legislation with respect to intellectual property rights, because two people can claim. See, even USA has tried to patent India's traditional knowledge of using turmeric. India's basmati rice they tried to patent. If USA has patented India's basmati rice, we have to pay USA so that we have to grow our basmati. We have to pay USA every time while we are using our turmeric to heal our wounds. So such disputes are always arising at the international level. Even in the state level, two people can also fight. Even in our country, two people also can fight upon a claim saying that this is my innovation. So for that legal legislative process, sometimes these patent laws, some company might steal your patent and say, no, this is my innovation, not his. So in order to deal such legal and legislative frameworks are being developed, we are creating commercialization, we are creating awareness programs, we are creating basic infrastructure so that intellectual properties are improving. As I said you, evergreening, patent evergreening is very, very wrong. What we have done. All these issues are provided here, my friends. So this is what you have to remember with respect to intellectual property rights. We have an Center for Intellectual Property Rights Management, CPAM, very, very important organization which is creating awareness programs for disseminating knowledge on intellectual properties. We have IP Nani, basically these two are mascots of intellectual property rights in India. This is IP Nani and this is Chotu. They both have conversations like this to say how intellectual properties are protected in India. One last intellectual property right that you have to remember is semiconductor and integrated circuit layout design. My friends, semiconductor and integrated circuit layout design, basically they are provided for a semiconductor design. For example, take your phone. That is a semiconductor design, right? Take your laptop, take your computer. They have some integrated circuits. And this integrated circuit should also be provided patent or protection according to law. Okay. I'll show you one important point. In India, basically these semiconductor layouts are protected under Semiconductor Integrated Circuit Layouts Design Act 2001. If someone is stealing your own semiconductor design, that is very, very wrong. So this is what about intellectual property rights, my friend. Hope you are understanding. So we'll meet in the next class. Thank you.